Hello, everybody.
Are 22 CR 322, 23 CR 38, 24 CR 191, and 24 CR 192. Announce appearances.
May it please the court, the state appears by Aaron J. Cunningham, Assistant Ellis County Attorney in all matters via Zoom.
May it please the court, the defendant Abraham Leon appears in person and through counsel Cassie Ziegler.
All right.
Your Honor, Christopher A. Rohr appears also on behalf of Mr. Leon.
Okay. We have two defense counsel, but Mr. Leon has also pro se filed a number of motions, I think petitions. I went through the files yesterday. He filed on September 12th a petition for habeas pro se. He filed on that same date, September 12th, a motion to suppress evidence pro se. On that same date, he filed a pro se motion to dismiss. He then on October 1st filed a motion to withdraw counsel for misrepresentation. I believe that is regarding Ms. Ziegler. Then on September 23rd, he filed a petition for hardship. And then on the same day, filed a petition for negligence of duty and bias and hardship. And then Mr. Rohr has filed a motion to withdraw. Counsel, did I get all of the various motions, petitions outlined correctly? Did I miss any?
No, Your Honor.
I don't believe so, Your Honor.
All right. Counsel, I'm going to ask you first for Mr. Leon regarding all of these pro se petitions. How do you wish to proceed regarding those?
Well, originally, last week Chris and I had a meeting with our client via Zoom and for almost 2 hours. And at the end of that meeting, our understanding this morning is that those motions would be withdrawn. But based upon communication from Mr. Leon's wife by email, that has apparently changed. He does not want them withdrawn and would like the two of us to withdraw as counsel.
Mr. Rohr?
Your Honor, that's correct. So we're at odds on how to proceed with the pro se motions. Ms. Ziegler and I did spend a lengthy period of time advising Mr. Leon how it best to proceed, how to proceed going forward. At the conclusion of that meeting, we thought we had an understanding, but then apparently we don't. And Mr. Leon's been nodding his head periodically throughout this conversation. So the last communication I have is he wants me to withdraw as counsel as well. He doesn't agree with advice that I've given him, and obviously he wants to proceed how he wants to proceed.
Well, I run into that a lot. We all want to do what we want to do, even if it's not in our best interest. But that's not the standard we use for, as you know, Mr. Rohr, and I'm sure you've explained to Mr. Leon, that's not the standard for withdrawal of counsel. Mr. Leon stands charged in the case you're appointed on with first-degree murder. In felony murder, 2 alternate counts, and then an alternate count of second-degree murder in that complaint. The panel of lawyers qualified to represent somebody on such a high-level felony, as everybody knows, is limited. And as such, I cannot let Mr. Leon engage in this revolving door of lawyers because we run out pretty quick. I've been through this before, and quite frankly, it is an abuse of the system. It delays the procedure and timeliness of the proceedings. And so we have to be very careful. Mr. Leon doesn't seem to have an understanding of what the role is of the attorney as it relates to the handling of the case, strategy, and those kinds of things. And so we need to have a conversation. I'm just not going to, because Mr. Rohr, I think Mr. Leon's already done this to a previous lawyer. And in fact, that lawyer is one of the few that's qualified on the high level. So and that was Cheryl Stewart on one of the earlier cases. He wanted her to withdraw and he disagreed with the way she was handling things. So if we lose you and we've already lost Ms. Stewart, we're running rapidly out of attorneys qualified to handle high-level cases. So I'm going to need more than just my client wants it, because that's not the legal standard.
May I speak, sir?
Not yet.
Your Honor, I understand what the legal standard is. There has to be justifiable dissatisfaction in the representation. Honestly, I was just recently appointed on this matter a few weeks ago. So I filed the motion to withdraw just to preserve that issue that he's requesting that I withdraw. At the conclusion of the 2-hour meeting with Ms. Ziegler and I thought we were on our way to an understanding on how to proceed. We had discussed on how we could have more constant communication with me being in Colby and him being in jail. We had talked about, filing a motion to have just any hearing transcribed, so Mr. Leon could just read what actually happened as compared to his mind telling him what he thought happened. So we had discussed things going forward at that meeting, but then we, as Ms. Ziegler pointed out, we received communication from Brandy, and at that point I just filed the motion to withdraw. Mr. Leon wanted to be heard on it, so I preserved it so he could tell the court how he feels.
Okay. All right, let's go through. I'll deal with the habeas because that was filed pro se by Mr. Leon, and I did not file it as a separate civil action because I wasn't exactly sure what he was denying. He's saying denial of bail. Bail has been set. He was denying speedy trial. That's not appropriate for habeas. And then he just has the basis of the detention. Well, the basis of the detention is he's charged with 4 separate felonies. So, and that's all it said, basis of detention. So I didn't feel there was sufficient factual assertions to justify any independent hearing, but I'll deal with him on that in a little bit. Motion to suppress evidence is something for the attorneys to handle. Motion to dismiss, again, something for attorneys to handle, unless Mr. Leon chooses to represent himself. And if he's going to do that, then he and I need to have a long conversation about the pitfalls of self-representation, particularly on cases of this magnitude. And then petition for hardship doesn't exist. I don't know what, and petition for negligence of duty, bias, and hardship. The most recent ones, I think those are directed most at Ms. Ziegler because he disagrees with the strategy she's using in the cases. So now Mr. Leon obviously wants his opportunity to address the court, but he does have, you're still both counsel of record. Neither one of you have been allowed to withdraw at this point. So how do you wish to proceed with him addressing the court directly?
I think I'd give him the opportunity to address the court, Your Honor. I wouldn't, generally, I'm not going to deny a defendant the opportunity to say what he wants to say. He's adamant he wants to say it. At this point, he can, I'm fine if he addresses the court, even with counsel sitting here. I don't know if Ms. Ziegler disagrees, but.
Well, I don't believe it's in his best interest at all, but he's been advised of that by both of us. And he is adamant about addressing the court. And I'm not really sure. My advice to him would stop that anyway, Your Honor.
Okay. Mr. Leon, the fact you want to do something doesn't mean I have to grant it. And that's not the way courts work. Okay. We have given you representation, which is what you're entitled to under the Constitution. And that's why you have lawyers. We're not going to proceed in this case with you filing your own motions and getting your own hearings when you're represented by an attorney. That's not the way it works. Do you understand?
Yes, sir.
That's not the way courts work. You go to any court in the country, they're not going to let you do that. You filing motions, we schedule those for hearing without your attorneys, and then your attorneys filing separate motions. That's not the way cases proceed, particularly not cases involving a potential murder charge, along with the others. The rest of them are methamphetamine and criminal damage to property. But the 24-191 is a case, and I'm sure it's been explained to you, the severity and significance of those charges, correct?
Yes, sir.
Okay. I'm going to grant it this one time, but I do not want you to ever get the idea that this all of a sudden gives you an open door to start scheduling your own hearings and filing your own motions. But because this involves allegations of you wanting both attorneys to withdraw, I will allow you to address the court so that I can factor that into whatever decision I reach. So, Mr. Leon, on this one occasion, the floor is yours.
Thank you, sir. Yes, I do have a statement here. It said, I've been represented in many ways, sir. According to KSA 22A 242, after my son was evaluated at the hospital, and with the history of SIDS in my family, sir,
We're not going to argue about the facts of the case, Mr. Leon. That's not what we're here for today.
I understand that. I understand that, but this is support. This is support to my reason that I want them withdrawn. I'm not addressing facts of the case, sir. What I'm saying is that according to that KSA, my wife and I should have been served with a autopsy, and the harassment there from that point on, because 243 says that the state should there should be a state review board consisting of the Attorney General, the Director of Kansas Bureau of Investigations, the Secretary for Children and Families, the Secretary for Health and Environmental and Commissions of Education, 3 members appointed by the State Board of Healing Arts, one of which should be the district coroner, and two of whom shall be the physicians licensed to practice medicine and surgery and specialize in pathology, and the other specializing in pediatrics. None of this has been done so far, and that's a violation of my due process. On top of that, sir, I was seen on July 9th and July 10th without my attorney of record, purposely by the courts, to determine bond, but with no bond violations. At that time or now, the present there was no legality on the hold that was placed on me. However, the 23rd Judicial District rule that states that Rule 207A and B, the dismissal for failure to expedite a journal entry, the cross references with Rule 170, preparation of an order, and Rule 12, journal entry preparations and submissions. The hearing for July 9th did not have a journal entry filed until September 6th, and there still is not a journal entry filed on the July 10th hearing. It was determined that there was the purpose of not filing journal entry were to keep the illegal hold on me, which stopped me from being able to bond out, and the state could amend my charges. I went to 3 different hearings to straighten out my bond issues. But because of the lack of the journal entries that were not filed, the violation of my due process and the hold was not lifted. The state amended my charges, and my attorney did not speak. Neither one of my attorneys spoke up and were willing to speak up on the fact that the journal entries were not filed. And at the 3rd hearing, the hold was finally lifted, but only because the charges were amended. My attorneys did not defend my 5th Amendment right to due process, which all these previously stated things that I just said that have been broken violate, especially the 2 journal entries not filed on time and one that's still not filed. She also allowed for the violation of my 6th Amendment right for me to be seen twice without her, and she's local, also violates my 6th Amendment right to legal representation. And again, is a 5th Amendment procedural violation. What's more is the fact that the 2 times that I was seen without her, an illegal hold was put on me that wasn't lifted until the 30th of August, and it was deemed the hold that was in fact not legal, is another 5th Amendment procedural violation, as well as an 8th Amendment violation that prohibits excessive bail and excessive fines, the cruel and unusual punishment. As decisions were made to put a hold on me that was illegal and held me until bond was unattainable before they lifted the hold. In fact, it is in fact cruel and unusual punishment, and the 8th Amendment violation. As the facts are stated, I would ask you guys to consider what's these things that I'm saying. In conclusion, Your Honor, I would request that the courts consider these facts as I stated them, and consider the Supreme Court Rule of 107, which addresses motions to dismiss and procedural. And based on procedural violations of these rules, I would ask the courts to consider the illegal hold, the 8th Amendment violation, the 2 court dates without my attorney, at which time I was seen and illegal holds were put on me, Sixth Amendment and Fifth Amendment violations to procedural issues. The second journal entry not filed on time, and the one that's still not filed, which is again a Fifth Amendment procedural violation and a 23rd Judicial District Rule 27 or 207 A and B, and the misrepresentation. The multiple times I've asked my attorney to please recognize these things and see that I'm being treated unfairly. And as the Rule 107 depends on the severity of the impact of the defendant's rights, I would ask the courts to grant the motion of Rule 107 based on the many violations on many different occasions as a remedy to dismiss all these charges against me, as the unfairness in the protocol or procedural violations to due process are clear and severe and suggest predetermined bias, and I would request the dismissal of the charges. Alternative, and then the alternative to that, I would request to be, because I have interviewed with Oxford houses every other week since I've been here. I've successfully completed treatment. I've been to every court date that I've ever had when I was on bond. I've never ran. I went to an open facility for treatment. I didn't run from that. I successfully completed that. I came back. I'm not a flight risk. I'm more than willing to go through follow whatever procedures I'm supposed to follow. But the unfairness, sir, in these judicial proceedings is unfair. And I've been so I would request that as an alternative, if I can't get the Rule 107, if I can't get the courts to agree with me with Rule 107, I would request to be able to release to the Oxford House, Wildcat, and Salina, which I have the reentry bed, and they're willing to take me. I would go straight from jail to there to continue fighting these cases and be able to defend myself. Because every time I try to ask my attorneys to defend me for something, they tell me that these aren't major violations, that these rules don't matter, and that they can be bent and broken and whenever the courts want, and that's not right, and that's literally what I spent the 2 hours talking to them about when I was in here, was the fact that they told me, the courts can break the rules as often as they like, and as long as it's not a major, but the repetitiveness of how many different times, and the fact that I was seen without my attorney, Ms. Ziegler, and illegal holds were put on me until the court had the opportunity to amend my charges up, and then the hold was lifted, and Ms. Ziegler was there at that point. And then after the hearing, she told me, well, if we would have had a treatment plan, we probably could have got you released to treatment, but and literally, sir, right after you walked out of the room. And so
Mr. Leon, the court wants to make sure the record is clear. You've made your argument. 22-322, you're charged with 4 felonies: possession of methamphetamine, fleeing and eluding, interference with a law enforcement officer, 2 counts, along with a weapon violation, which is a misdemeanor, and a paraphernalia charge. After you were charged with that, you then were arrested again on new charges: criminal damage to property, which is also a felony; interference with a law enforcement officer, also a felony. Then after that charge, you were then investigated for a potential death case, originally charged as a level 5 aggravated battery, then amended to felony murder, 2 alternative counts, or second-degree murder, the 3rd alternative count. And then along with that case, charged with, again, possession of methamphetamine, possession of paraphernalia. The court made a previous finding that because you have had a 22-322 case, which, by the way, you sent a letter to the court admitting basically and confessing to those crimes, unsolicited, you've then been charged with 3 additional felony cases. You are as the court noted earlier, you are a safety risk to the community as a result, and that's the reason bond was discussed, and bond for a murder case in the sum of $500,000 is more than reasonable. We have gone through this before. There's no reason the court's going to revisit it now, but I wanted the record to be clear as to the number of cases you're charged with, many of those cases while you were out on bond on the earlier case. So as far as you didn't mention anything about the attorneys except that you have a disagreement about strategy. That is not grounds for the attorneys to withdraw. We have a limited number of attorneys that can represent you on a murder charge, and I am not going to allow Mr. Rohr to withdraw on that basis. Now, Mr. Rohr, I do want to ask you, because you are new to this, because of the severity of the charges against Mr. Leon, and I'll ask Ms. Ziegler to weigh in. Would it be better if you were assigned all 4 cases at once so that he has one attorney to deal with rather than having 2 counsel? I'd like you to at least address that to see whether that might assist in the representation of Mr. Leon. So, Ms. Ziegler, I guess I'd ask you first, do you think that would be in your client's best interest?
I do, Your Honor. That was actually something at some point I was planning to address. I think it would be helpful because right now I'm the counsel on all of the other cases. It would be helpful to have Chris on there as well. I would assume, we're going to have to, I don't know if we're going to do these piecemeal or we're going to come up with a global resolution or we're going to go to trial on some and not on others. So yeah, having Chris on those would probably be helpful.
So you would want to stay on the case and have Mr. Rohr assigned also as co-counsel, and then you would want to be assigned as co-counsel and assist second chair on the murder case?
Yes, Your Honor.
Mr. Rohr, what's your opinion regarding that?
Your Honor, that's fine with me. I think that works, and then I have no objection to that.
Would somebody take the initiative to contact bids to make sure that they don't have an issue with assigning Ms. Ziegler on the 24 CR 191 to have her co-chair on that murder case?
Yeah, I can reach out to Emily, the witness and attorney coordinator through bids.
Okay, let me know. And if that's okay, I think that's best. Mr. Leon has a propensity for filing a lot of pro se motions. And this way I have both attorneys on every case so that you're all getting copies of any of those he might file. So I'm going to proceed accordingly. As soon as I hear from Mr. Rohr that he's got approval of bids, I will appoint Ms. Ziegler as co-counsel on 24 CR 191, and I'll appoint Mr. Rohr on the other 3 cases.
Your Honor, just to clarify,
yeah.
I think I might already be on 191, but I still think it would be good to clear it with bids. I was appointed when it was a level 5.
Level 5, right.
Right.
Okay.
Yeah.
That may be correct. So, and then we had to appoint Mr. Rohr because of the jumping it up to level 1s or off grids. All right.
Yes.
Sir,
And so we will do that. Regarding the habeas petition, the court doesn't find that there's sufficient basis for that. And we will, it'll be summarily dismissed and Mr. Leon, you can discuss with your attorneys. You just said you allege habeas and you say the basis for the detention, but you don't argue as to what the facts are. Visit with them if you want to supplement or file a new habeas and assert sufficient grounds. The court will take a look at that at the appropriate time. Denial of bail and speedy trial, those issues are not appropriate for habeas. And if those want to be raised separately through your attorneys, that's fine. Mr. Leon, the court's going to caution you not to continue to file a lot of pro se motions. You can discuss with your attorneys whether they believe motions such as suppression of evidence, motion to dismiss should be filed and pursued. Those are strategies that they basically have the decision-making authority on. So visit with them about that. Apparently you have good communication with them. You spent 2 hours with them the other day, and they thought it was a fruitful conversation. So I would encourage you to continue with that. You can continue to file requests that they be ordered to withdraw, but it's going to take more than what you've asserted so far. And I'm not going to accept at this point lack of communication, because the lack of communication is your failure to cooperate with your attorneys. They both have your best interest at heart. They're both competent counsel, and your opportunity for other attorneys to step in are very limited. And the court is not going to go down that road knowing the very small stable of attorneys qualified to handle these kinds of cases. So Mr. Rohr and Ms. Ziegler will continue as your counsel pending any further hearings. Mr. Cunningham, anything that the state wants to add?
No, Your Honor, I don't believe so.
Sandy, was there something that?
I just want to confirm, since counsel is going to continue, we are scheduled for prelims on all cases November 13th, all day in front of Judge Brown. Are we all still in agreement that's going as planned?
I don't believe that I have issued formal subpoenas, but I did contact my key witnesses and make sure that they would hold that date. And now that we know that we're moving forward, we'll issue those subpoenas today.
Okay, I just want to make sure that we had
Ms.
everybody on the same
Mr.
page.
Rohr, Ms. Ziegler, do you think you'll be ready for November 13th for the preliminaries?
Yeah, so I'm gonna reach out to a medical expert to try to get a second opinion. I'm gonna do that this week. And so as of right now, I think we'll be prepared, but that could change depending on if I find something else out.
All right. Well, the earlier the better, because Mr. Cunningham's going to be sending out subpoenas, and my calendar availability, while it's a little better than it was a few weeks ago, my window of opportunity is closing rapidly as far as the service as the district judge. So we want to get this heard because obviously Mr. Leon is raising speedy trial. There's no statutory speedy trial problem. Even the 22-322 case, he's never been arraigned on. We haven't triggered the statutory speedy trial in any of these cases, but there is still the potential issue of a constitutional speedy trial. So we want to make sure, since he's raised it, that we're sensitive to that.
Yeah, I will let the court know by the end of this week if the setting on November 13th is going to be an issue.
All right. Okay. Anything further before we adjourn?
Not
No,
necessary.
Your Honor.
No, Your Honor.
Sir, I just want to say that I just want to put it on the record that I don't really agree with your ruling, but I just wanted that down for the record.
Oh, that's fine, Mr. Leon, and Mr. Cunningham will prepare a journal entry today, and I just add that line so Mr. Leon's satisfied that he personally objected to my ruling.
Thank you.
Yes,
All
Your
right.
Honor.
With that, we will be adjourned.
Thank you, Judge.
Morning, counsel.
Morning.
Morning, Your Honor.
The court will call 4 cases, all of them captioned State of Kansas versus Abraham Leon. Case numbers are 22 CR 322, 23 CR 3038, and 24 CR 191 and 192. Announce appearances.
May it please the court, the state appears by Aaron J. Cunningham, Assistant Ellis County Attorney.
Your Honor, Mr. Leon appears by Zoom and through counsel. Christopher A. Rourke Colby and Cassie Ziegler of Ellis County.
All right, Mr. Leon, do you have any objection to us conducting this hearing by Zoom?
No.
Very good. This before the court on the defense counsel's motions to withdraw. Those were recently filed as of actually yesterday, and both counsel asked for an emergency hearing or as early as possible. Mr. Leon, are you ready to proceed on your counsel's motions to withdraw?
I am, sir. And then I'd like to address the courts if that's okay.
Well, we'll see. Let's get to the motions first with the attorneys. Besides what's in the motion, is there anything additional that either attorney wants to present?
Your Honor, I think that the only thing, anything additional I present, I think given Mr. Leon's, I think behavior, demands, threats, his actions, going through with those threats, I think the trust between the attorney and client's broken, and I don't know how you fix that.
Okay. Ms. Ziegler, anything additional besides what Mr. Rohr said?
No, I totally agree with Mr. Rohr, and I don't think I have anything else, Your Honor.
Okay. Ms. Leon, I will now invite your comment. Leave it strictly to this motion to withdraw. Nothing else about the case, because that's not what's before us today. You understand?
Yes, sir. I do have, yes, sir. So,
okay. Regarding the motion to withdraw, do you wish for these 2 attorneys to withdraw?
So I've asked my attorneys to file a motion multiple times on a procedural timeline error of not having me into a preliminary hearing within 14 days. This right is guaranteed to me per the state statute 7.2 and supported by my 4th Amendment right to due process and incorporated by my 14th Amendment due process clause. State versus Fink does guarantee the defendant the right to be within a preliminary hearing within 14 days. And I've asked them both to file these motions. Neither one of them are filing these motions. And I would ask the court to consider these motions as well as, I haven't asked them to withdraw. They said I've just asked them simply to do something. Your Honor has already ruled on this and told me that he was not going to allow them to withdraw because of the state's short amount of attorneys that can handle these cases. So I have not asked them to withdraw at all. I've simply asked them to invoke and enforce my, or ask the courts to enforce my my right to due process in my 14th Amendment due process clause, because there is a procedural timeline error, and they continue to try to dissuade me from bringing this to your attention, saying that it's not correct. But I have the state statute pages right out of the book that an attorney has sent in that does guarantee me these, says that it does guarantee me the right. While it's not, preliminary is not, you know, like mandated, it's not constitutional. But in that case, I would then need to be to an arraignment within 10 days. I've not waived that right. And my attorneys of counsel, my attorneys, I've brought this up to them multiple times. Cassie hung up on me once when I was trying to talk to her about it. Mr. Rohr has said that he was going to bring the issue up to you, and then next thing I know, he was telling me that the next thing I know, I'm getting a motion saying that you guys are going to withdraw. They're trying to withdraw the counsel. I didn't ask them to withdraw. I took your ruling on the matter last time seriously, is that you were not going to let them withdraw. I'm not asking that they withdraw. I'm asking that they represent me to their fullest of capabilities in this matter of my the procedural timeline.
Okay, so Mr. Leon, your basic argument with your attorneys right now is that you want them to file a motion to dismiss your cases for failure to bring you to preliminary hearing within 14 days, correct?
That and there are other matters, sir.
Okay, well, that's what you started with. Let's just begin.
Okay.
With, all right.
Okay.
Your attorneys both know the law. Now, you've noted the statute 22-2902. Okay, but they also know the law. State versus Weigel, the Kansas Supreme Court ruled in 1980, quote, the time limitations in 22-2902 are directory and an inconsequential delay beyond the time specified for holding a preliminary hearing will not justify a dismissal. That is the law in the state of Kansas. It has been the law since 1980. It has not changed. And so your attorneys are aware of that, as is the court and the prosecutor. They do not have an obligation to file frivolous motions. And so your argument with them is that they won't do what you direct them to do, and that is not their responsibility. I explained this to you before. How an attorney handles a case, the strategy is their decision, not yours. You have input, they will listen to you, they will incorporate your thoughts, but they will do what they believe is in your best interest under the law. They are not there to do what you tell them to do. Rather, they're there to represent you zealously and as advocates within the ethical boundaries that are set there. That's the rule. So
But
you can sure tell them, I would like you to file this motion because I think it's a violation. And they would say, well, we understand you read it that way, but it's already been in front of the Kansas Supreme Court and they disagree with you. And that's the highest authority in this state. So,
but Your Honor, State versus Fink says that I have this. Hold on.
Yet I'm telling you, Mr. Allen, I'm not going to have a legal debate with you. Okay, I'm telling you, I gave you the case citation. It is not the only Kansas Supreme Court case that is ruled on this issue. It is directory, not mandatory.
I understand that, sir. I've been up here for 150 days without a preliminary hearing or any type of court proceeding. That's a clear abuse of power.
Well, that's a different argument. And we're not going to, I told you we weren't going to get into that. We're here to talk about whether I'm going to let your attorneys withdraw or not. Okay. But I wanted to give you at least the law to explain why they don't do everything you ask them to do.
Your Honor, that doesn't tell me anything about the procedural timeline error, though, that I've been asking them to represent me on. The procedural timeline error does say, Your Honor, that an abusive process cannot be done. I've been up here for 150 days, and I've asked my clients to please represent me in this, or not my clients, my attorneys to please represent me in this matter, and they have not done it. And they can't give me a reason. They can't give me a KSA. They can't give me any of that. And it also says, Your Honor, that I am entitled to being into a preliminary hearing or an arraignment within 10 days. I've been up here for 150. This is an abusive process. This is
Okay, I've listened to this before. This is what we're here for today, is your attorney's request to withdraw. Here's what the court's going to hold. You can keep filing ethical complaints on them. You can keep doing whatever, all of these pro se filings. I mean, you have a lot of time on your hands up in jail. So I'm not in any way telling you that you're prohibited from doing that. But they will control the strategy and the procedure in the representation of you. And here's the bottom line, Mr. Leon. I could appoint every attorney in the state, and they're going to have the same problem with you that these two attorneys do. That's the criteria I have to look at. Okay. If you don't like it, go hire your own lawyer. Okay. That's your choice. But if you can't hire a lawyer and you apply to the court, you're going to live with and deal with the competent and qualified lawyers that the court appoints for you. That's the law. All right.
Okay, sir.
So learn to live with it and learn to cooperate with them, because I'm not going to let them withdraw, because if I do, the next lawyer I appoint, I'm going to have the same argument. And here's the other thing, Mr. Leon. Your main argument is, Judge, I've been up here 150 days. I want my day in court. If I appoint a new lawyer, they're going to have to review all of the discovery in this case. They're going to have to interview witnesses. They're going to have to communicate with the prosecutor. They're going to have to visit with you. That takes time. And that you're not the only client they have. So that time is longer. So the very thing you're complaining about, if I grant the request that they're making on your behalf today, only increases that very time standard. The very key problem you're talking about. It's counterproductive.
I understand that. I'm
it.
not asking that. I'm not asking them.
No, I'm done. I am denying the motion to withdraw at this time.
Will you
and
go
I
on the
appreciate-
procedural timeline, Aaron?
Okay. Jailer,
Yes, sir.
put him on mute. I'm not going to have him interrupt me anymore. Thank you. Counsel, I just wanted to express to you that I appreciate the dilemma you have. It's not the first time you have gone through something like this. I'm denying your motions at this time for the reasons I recited. Number one, any other lawyer I appoint is going to have the exact same problem. I'm just going to keep repeating it. And number two, if I appoint new counsel, it's going to further delay the hearing, and we already have a preliminary hearing scheduled. And I'm not going to delay it another 100 days or 150 while a new attorney gets up to speed on the case. This defendant's complaining that he wants to get into court. We're going to give him that because it's scheduled, and we're going to go forward with it as scheduled. Understood?
Yes, Your Honor.
Yes, Your Honor.
Very good. Okay. Anything else that you need to address with the court today?
No, Your Honor.
Very good. All right. We are scheduled for preliminary. When is that again?
Next week.
Next
Wednesday.
week.
The 14th, 13th. It's the 13th.
Yeah, I knew it was coming up. I knew it was next week sometime. Let me look here. Yeah, we're scheduled for an all-day preliminary next week, Wednesday, a week from today. So since Mr. Leon's main complaint is, I want to get my preliminary, we're just going to get it a week from today. And if we hire or if we appoint new counsel, it would be delayed probably well into January or February next year with the holidays and the scheduling problems. So we will give him what he wants. I will expect that you will visit with Mr. Leon about his conduct in the courtroom. In other words, that he is not to interrupt either the judge or witnesses, that he is to listen to the evidence, that if he needs a recess to visit with you, the court will accommodate that and allow you to go into chamber or into the conference room to do that. I know he's listening to this, and I'm hoping he's paying attention, because I will not tolerate the kind of conduct that we had exhibited today, where he continually interrupts and continues to repeat the same arguments. So he's going to get a preliminary hearing as he desires, and it is a week from today. And with that, we will be adjourned.
Thank you, Your Honor.
Thank you.
you.
Your Honor.
Mr. Cunningham, unfortunately, I'm going to ask you to do the journal entry from today.
I understand, Your Honor. I will.
Be safe, be well, sleep sweet, and much love.